This is the 16th part as far as our lecture series is concerned. During the last part, we had started our discussion to know the various codes that are constituted by the provisions of the Criminal Procedure Code and their powers. And in order to know various codes and offices as far as Criminal Procedure Code is concerned, it is must for us to refer to right from section 6 up to section 25A of the Criminal Procedure Code. In order to know their powers, we have to start right from section 26 and come up to section 35 as far as the Criminal Procedure Code is concerned, which is the next chapter. What we will do, we will, in order to know the various codes and their power, we will take these two chapters together to be read with what? As I have told you earlier, just to refresh your memory, to be read with third vertical column of the first schedule of the Criminal Procedure Code, to be read with last vertical column of the first schedule of the Criminal Procedure Code. And during the course of lectures, we decided let us try to understand hierarchy of the criminal codes, the ladder of the criminal code, the chain of the criminal code, and hence we started with Supreme Court, High Court, Court of Session, Additional Session Judge, and Assistant Session Judge with their powers. So we have to, and what do you mean by power here? By power we mean what is the maximum punishment that can be inflicted by the court is the power of the court, and then this can be understood as you have reference to third vertical column to be read with last vertical column, namely sixth vertical column of the first schedule of the Criminal Procedure Code is concerned. With this now, for every district we have got a person who is head of all the magistrates within the district is concerned, and he is known as Chief Judicial Magistrate. The power that can be exercised by the Chief Judicial Magistrate is he can pass a sentence up to 7 years imprisonment. He is head as far as all the magistrates within the district is concerned. In order to help him, there is a provision of having additional Chief Judicial Magistrate, and when I refer to the additional is administratively subordinate, but the powers are the same. So additional chief power to pass a sentence up to 7 years imprisonment only. With this now, we come to the court of Judicial Magistrate First Class. Now, Judicial Magistrate First Class can pass a sentence up to 3 years, and he can impose a fine up to 10,000 rupees. This is the first time that there is restriction as far as the amount of the fine is concerned, namely 10,000 rupees. But when I refer to this particular amount, namely 10,000 rupees, a time for me to draw your attention to Article 246 of the Constitution of India. To be read with what? To be read with 7th schedule of the Constitution of India. And when you start reading, you come across list 1, which is union list, list 2, which is state list, and the third list is what is known as concurrent list. Why you should know this? You should know this because if the law falls under what is under the union list, if the matter falls under union list, there can be a law by the central government. If the matter falls under state list, there can be a law by the state government. And if it falls under concurrent list, there can be law either by the central government or by the state government. It's not only enactment of the law, but whenever amendment is required to be carried out, the amendment can also be carried out taking into consideration 7th schedule of the Constitution of India. Criminal law falls under the matters enumerated as far as concurrent list is concerned. Hence, there can be amendment as far as criminal law is concerned either by the central government or by the state government. If you refer to your Bare Act, you will come to know that this law, namely as far as the amount of the fine that can be imposed by the Court of Judicial Magistrate varies as per the state, for which you can have ready reference by reading the amendments which are given after the concerned section. As far as the state of Maharashtra is concerned, the maximum fine that can be imposed by the Court of Judicial Magistrate first class is 50,000 rupees. It's not necessary for us to work out details as far as the amendments which are carried out by each state is concerned. But you must remember that this power will entirely depend upon, or you must know this, taking into consideration the state where you are practicing accordingly, and that is the only point with which I wanted to draw your attention. Judicial Magistrate first class can pass a sentence up to 3 years and fine up to rupees 10,000. Judicial Magistrate second class can pass a sentence up to 1 year and fine up to rupees 5,000 only. After this court, you have a court of Special Judicial Magistrate. Special Judicial Magistrate shall enjoy the same powers which are enjoyed by the Court of Judicial Magistrate second class. But his appointment is not forever. His appointment only for a period of 1 year, and there can be extension, and he is supposed to deal with a particular type of cases, taking into consideration the arrears of cases which is pending as far as that particular area is concerned. With this now, one more, district cannot be entirely managed by Chief Judicial Magistrate, and hence a Judicial Magistrate first class is head of a particular division, and he is known as Sub-Divisional Judicial Magistrate. Powers are the same as far as Judicial Magistrate is concerned. This is as far as the district is concerned. But the time for me to draw your attention to metropolitan city. This metropolitan city was prior to it known as presidency towns, and now this is known as metropolitan city, for which when you start learning criminal procedure code, you have to read section 2 subclause K to be read with section 8 of the chapter with which we are dealing at present, which is what is known as metropolitan city. And then if it is a metropolitan city which is required to be notified in the official gazette by the government accordingly, then for that metropolitan city, as far as the chief of all the magistrate, head of all the magistrates is concerned, he is Chief Metropolitan Magistrate. Chief Metropolitan Magistrate can pass a sentence up to 7 years imprisonment. To help him, you have got a court of Additional Chief Metropolitan Magistrate. Then we come to the court of Metropolitan Magistrate, who can pass a sentence up to 3 years and fine up to rupees 10,000. And the last court is the court of Special Metropolitan Magistrate, whose appointment is only for a period of 1 year, and the power is he can pass a sentence up to 1 year and fine up to rupees 5,000. If you remember the heading as far as chapter right from section 6 up to section 25A is concerned, this deals with various courts and offices. So now this is a time when we will deal with who is public prosecutor, who is assistant public prosecutor. We will come to know during course of time as we proceed to deal with the provisions of the Criminal Procedure Code, no doubt about it. But one more aspect as far as the criminal courts are concerned, of which we have to take note at this point of time, and that is the courts of executive magistrate. In order to know details regarding executive magistrate, we have to read right from section 20 up to section 23 of the Criminal Procedure Code. For every district, executive magistrate, who is head of all the executive magistrate within the district is concerned is known as district magistrate. To help him, we have course of additional district magistrate. 3. Subdivisional magistrate, executive magistrate and special executive magistrate. These are the courts as far as executive magistrates are concerned. What are their powers? They are not supposed to discharge judicial functions, nothing to do as far as trial is concerned. Their job is administrative or police in the nature is concerned. Now, during course of learning criminal procedure code, we shall be dealing with the powers of the executive magistrate, no doubt about it. But as I have referred to this, let me draw your attention to section 176 of the criminal procedure code, where inquest, namely the inquiry to find out cause of death when the death of the person has taken place when he was in the police custody, is required to be carried out by the executive magistrate. Section 174, when the death of the person has taken place under suspicious circumstances, executive magistrate will carry on inquiry for the purpose of finding out cause of death. Right from section 106 up to 124 of the criminal procedure code, where we talk about or deal with security for keeping the peace and good behavior, the matter is inquiry is conducted by executive magistrate. When we will refer to the provisions regarding dispersal of an unlawful assembly, or removal of a public nuisance, or urgent cases of nuisance or apprehended danger, or disputes regarding immovable property, executive magistrate will come into picture. So now, or there are many provisions where a search warrant can be issued by the executive magistrate, or if you refer to section 43, executive magistrate has got power to arrest a person also. In other words, executive magistrate shall be dealing with the nature of the work which is not that of judicial officer, namely imparting justice or finding out guilt or innocence of an accused person, but his job is different, namely police or administrative in the nature, with which we shall be dealing, and we shall continue during the course of time as far as our lecture series is concerned. I mean, at this point of time, it may not be possible, and you may not be in a position to remember all powers that are that can be executed or that can be exercised by the executive magistrate, but I have already enumerated. I repeat it, it's a enumeration. The list is not at all exhaustive. When executive magistrate will come into picture, and what is required to be done on the part of the executive magistrate as far as criminal procedure code is concerned, and rest of the details with which we shall continue during course of our time. Now, this is a time where we have come up to section 35 of the criminal procedure code. Now, during the next part, we shall be taking into consideration the most important aspect of the criminal procedure code as to setting criminal law into motion, and for that purpose what is required to be done on the part of an individual, whether he is bound by law or not, that is required to be understood in the context of the next chapter, namely right from section 36 up to section 39 of the criminal procedure code, with which we will continue our discussion as far as next part of our series of lecture is concerned.